Hello, hello, hello.
Hello, can you hear me? Hi, can you hear me? Hello.
Yes, you're audible.
Hello, can you hear me? Hello. Hello.
Yes, ma'am, we can hear you.
Thank you.
Good morning, ma'am. We'll be starting in the next 10 minutes.
Okay, thank you. I will need to leave in half an hour, so I hope that is all right.
Ma'am, we're starting in 2 minutes. Thank you.
Good morning, everyone. Please start. Good morning, one and all. It is my proud privilege to welcome all the members, guest participants, and faculty members. This is a proud moment for RGNUL that we are indulged and engaged in contributing from our side in this right to information era. The Rajiv Gandhi National University of Law, since its beginning, when Professor Jaswal sir was the Vice Chancellor, organized so many events in association with the Right to Information Commission Punjab. And in due course of time, uh, as is explained by the student, that we have already organized so many events. Every year we have almost organized one or two events, and we have also contributed in terms of various kind of publication in the right to information. The recent development in uh, this part is that we have started a right to information certificate course in association with the Right to Information Commission, where within a very short period of time, around 1,000 of students and other participants, they have undergone with this certificate course, which provides the basic information and understanding about all the dimensions of Right to Information Act. All these activities show that Rajiv Gandhi National University is very sincerely working and contributing for advocacy of the right to information, and for which the Center of Labor Welfare and the coordinator, Dr. Gitika, Dr. Shruti, Dr. Rashna, and all the student members, they are playing a very important and vital role for spreading the information regarding right to information. Since the guests are there and we all are waiting, Madam Anjali Bharadwaj has to leave a bit early, so I will not take much time. Today we have with us Honorable Professor Paranjit Singh Jaswal, the former Vice Chancellor of Rajiv Gandhi National University of Law, former Vice Chancellor of Hidayatullah National Law University, and at present the Vice Chancellor of SRM University. And we all know that his contribution for development of this university, sir, being the source of inspiration for all of us, has contributed in each and every dimensions. This beautiful campus is the major contribution to build up this campus was during the tenure of Professor P.S. Jaswal, sir. Academically, sir has contributed more than 60 papers in different dimensions. His area of research is constitutional law, administrative law, right to information, and published more than 40 books, including constitution and right to information, administrative law. Sir has also guided more than 50 candidates for PhD and awarded so many prestigious awards, be it as a Career Award of 1994, University, State Government, National, and UGC, Eminent Great Personality of India, Honorary Rank of Colonel, DAV Educational Managing Committee, Award of Excellence for Outstanding Contribution by Maharaja Agreshan University, Shah-e-Hind Award, then Fulbright Fellowship by United States Educational Foundation, MIT Academic Excellence Award 2019, Indian Educator Award 2021, award of Best Vice Chancellor in 2022, and so many. If I start reading all his contribution, for us it may take more than an hour to explain everything. On behalf of the university, sir, we welcome you and we are thankful to you for providing your guests this time and gracing this occasion. Welcome, sir. Our another guest is Professor Kaushik Kumar Rawal. He is the guest from Gujarat University. And sir has contributed so many publications. He has published more than 25 books, around 60 various papers. His recent book is Law and Social Transformation, which is published by Allahabad Law Agency, which was considered to be one of the most sought after the book, because nowadays the Law and Social Transformation has become a compulsory paper in LLM course. So sir has compiled all the syllabuses and published a very recent book, which was in demand and required by most PG students. And he's otherwise also contributed so many different kind of articles relating to right to information and public law. Sir, on behalf of the university, we welcome you. Our another guest is that shows the dedication of his to participate and explain and discuss about the right to information. Professor Jeet Singh Man is the Associate Professor at National Law University, Delhi, and who is also the coordinator of the Transparency and Accountability Center, which has published and worked so many in different areas. And his recent book is published by China regarding labor law as well as various dimensions of right to information. So on behalf of the university, we welcome you also. And we also have Anjali Bharadwaj, madam, who could not make it possible to come offline, but we are thankful that you have joined online, madam. On behalf of the university, we welcomes you. Friends, with regard to right to information, we all know that when this enactment was there in 2005, before which so many judgments where the judiciary has realized that this is the time where the people should be provided this opportunity of having the information and right to know being the part of Article 21 and Article 19 was ensured. But at that point of time, there were so many queries and questions in the mind of administration as well as the people, those who are working as an administrators. And within this 15 years or more than 15 years tenures, still some of the hitches in the mind of the people, those who are working, they are still feels that the information at large should not be shared, or sometimes they have a fear in the mind that if they will share the information, then they may have some kind of problems which are faced. So one of the aspects which requires the required record keeping and making the people aware, in addition to the kind of training programs which are required to be organized for PIOs and APIOs, so that this kind of fear which is there in their mind, majority of the things are delays because that either the majority of the things are in so many offices, public offices, people they do not know how to keep the record, how to prepare the record. So if the record is available, then it can be shared. So this and another criticism which is there, decision-making process. Many of the people say that the decision-making process has delayed because of Right to Information Act, which in due course of time, people are realizing that it is not the delay in decision-making process. Rather, it is a tool of ensuring the transparency and good governance. So with this, where we all are of the view that the right to information is a tool to establish a good governance and transparency and accountability, where majority of the participants, they will discuss on different dimensions of the Right to Information Act, challenges, and if possible, we will also suggest if there are major contribution in terms of what kind of recommendations we can make to make it more feasible and workable. That should be noted down, and as a success of this seminar, we can recommend it to the agencies who can think on making different changes in that. With this, once again, I am thankful to each one of you who has made this possible to organize this event. Thank you, one and all. Please unmute.
Thank you.
Madam, are you able to hear us?
I can only hear when you are speaking, unfortunately. Otherwise, I'm unable to hear. Maybe the mics are not connected otherwise. So would you like me to speak now?
Yes, ma'am, please.
And
Over to
for how long shall I speak? Please do indicate to me.
5 to 10 minutes, ma'am.
Sure. Thank you so much. Thank you, first of all, for having me here. And it's an absolute pleasure to see, even though it is online, that so many students of law are engaging with the Right to Information Act. And I congratulate you, and I apologize that today, because I'm not in the country, I could not join in person, and it's very much something that I would like to do in the coming days. As you mentioned, the right to information is a fundamental right. The Supreme Court of India, in a host of judgments, has upheld the right to information to be a fundamental right of the citizens of India. And in fact, the court has held that it flows from Article 19(1)(a) and Article 21 of the Constitution. Basically, the court said that in a democracy, unless people have information, they cannot have free speech, they cannot exercise their freedom of expression. Also, to lead a life of dignity in a democracy and to participate meaningfully in a democracy, the Supreme Court has held that the right to information is central. And therefore, even as back as the 1970s, the Supreme Court upheld the right to information to be a fundamental right of the people of the country. The problem, of course, was that there wasn't a system to operationalize this right. And in the absence of a statutory framework, it became very difficult for citizens to try and access information. So for ordinary citizens, if they went into a government department, to a public authority, asked for information, they would not be able to access the information they were seeking in most cases. And therefore, there was a long movement, a struggle, a people's struggle, demanding that a right to information law be passed. In India, before the central law came about, the national law came about, there were 9 states that passed state information laws that included Maharashtra, Karnataka, Delhi, Goa. There were 9 states in all. And it was through the use of the state laws in these states that people further realized how important accessing information from the government was for them to truly participate and to be truly engaging in democracy. And the movement for the right to information, which started in the 1990s, was a very, very strong grassroots movement. It did not just involve the academics, the lawyers, the intelligentsia, but also people who were from the marginalized communities, people living in slum settlements, people living in remote villages, who started understanding the importance of information and demanding an RTI law. In 2005, when this law came, it came as a result of a strong people's movement, and therefore the law was very, very powerful. It took into account all the problems that people used to face while accessing information. So the law as it stands today, which was passed in 2005, is considered one of the most powerful right to information laws globally. In fact, there is a global ranking that happens, and I think consistently from the time that the law was passed in India, it has ranked amongst the top 10 in that ranking. But even more important is how the law has been used. The RTI law in India has been used very, very vibrantly. There are about 4 to 6 million RTI applications that are filed every year in India. This is the highest number globally. And the law is not just used by the lettered. The law is used by the poorest and the most marginalized to access information and get their basic rights by holding governments accountable. People have used the law to access information about their rations, their pensions, their scholarships. People have used the law to access information about education in government facilities. They have used it to understand what is happening in the hospitals that are funded with public money. So the law has been used to access information, and with the use of that information, people file complaints, they file grievances, and make sure that their rights and services accrue to them. So if there is corruption, the law has helped unearth corruption. I think there is not a single major corruption scam in the country that has come out in the last 18 years without the use of the RTI law. Also, the law has been used to hold the highest offices to account. People have used the law to ask about the assets and liabilities of judges of the Supreme Court, of the high courts. They have asked about political party funding. So people have used the law to not just ask for information about their basic rights, but also to hold the highest offices to account. And I can't think of any movement in the country which has not used the RTI law to further its struggles, whether it is the environment movement, mining, food, movement against hunger and malnutrition. All of them in the country have used the right to information law to access information and further their struggles and demand the rights that are due to us in a democracy. Of course, the problem has been that there has been a backlash. So governments, this is a global phenomenon. Governments are typically not very happy when asked for information, asked for transparency, accountability. And therefore, we have seen, even in India, there has been a backlash. We have seen this backlash take several forms. The first, of course, is that the Information Commission set up under the law has a very, very important role to play. If as citizens we don't get information, we can go to the Information Commission, which is an appellate authority, independent appellate authority under the RTI Act. And they have the power to direct governments to give information, even where governments don't want to give information. They can penalize government officials who don't share information or violate the RTI law. So these commissions are very important. Governments have understood that. We have been doing research to see what is happening in the commissions. And one very important finding that has been there is that the governments are not making appointments in a timely and transparent manner to the information commissions. So the commissions, when there is a vacancy, when a commissioner retires, whether it's at the center or in most of the states in India, there are no appointments that are made in a timely manner, which results in the information commissions not having an adequate number of information commissioners. All information commissioners in the country under the RTI law have to have a chief information commissioner and up to 10 information commissioners, according to the workload that they have. But we see that there are a very large number of backlogs and pendency in the commissions, and yet information commissioners are not appointed, which leads to further increasing the backlogs. Currently, the backlogs in the information commissions in India stand at about 3 lakh cases. So around 3,20,000 cases are pending in all the information commissions put together in the country. This basically means that people have to wait a very long time to get their cases heard in most of the commissions. So if one looks at commissions like West Bengal, commissions like Odisha, Maharashtra, they have large pendency, very few commissioners, and it is taking a very, very long time for hearings to happen, more than 5 years, 4 years, where people have to wait to get a hearing. So you can imagine that if an old woman is not getting her pensions and she files for information requests and doesn't get information, she goes to the commission. If she has to wait for 4 years, 5 years to get a hearing in the commission, what use is that information to her? So basically, it's like justice. If information is delayed, information is effectively denied. The RTI law becomes useless for people. And in places like Jharkhand, Tripura, Telangana, currently the information commissions are defunct, which means there is not a single information commissioner in those commissions right now. So governments are in a sense, weakening the right to information, people's right to information, by not appointing commissioners. Also, in 2019 and again in 2023, last month, the right to information law itself was amended. In 2019, the amendment was to reduce the autonomy of information commissions, because under the right to information law that was passed in 2005, the salaries, the tenure, and the pensions and other terms of service of information commissioners was fixed. It was at the level of the Supreme Court judges. But now an amendment was brought in 2019, which basically says that the central government will decide the tenure, the salaries, the pensions of information commissioners in all commissions in the country. Now, this basically means that a commissioner would have to understand that if they give an order which the central government does not like, then their pensions might get affected and so on. So this really reduces, this is a blow to the independent functioning and autonomy of information commissioners. In 2023, the data protection law was brought, and in the Digital Personal Data Protection Act, which was brought in August 2023, one provision says that the RTI law will be amended. Basically, what has been done is that Section 81J of the RTI Act has been amended to increase the information that is exempted from disclosure. So the law earlier said that personal information, which has nothing to do with public activity or interest, or that causes unwarranted invasion of the privacy of an individual will not be given under the RTI law. That was done to balance privacy and right to information. But now the government has brought in this act through the parliament, and the amendment which is brought in through the DPDP Act basically says that all personal information will be exempt, which means that even personal granular information that people need to hold governments accountable, to be able to get information about rations, the list of beneficiaries, who's getting rations, who's not, so that corruption can be stopped, the voter list, which has people's name, which is personal information, their address, their photographs, all of this could potentially be taken out of the ambit of the right to information law now that the amendment has come through the data protection law. So what do we need to do now? I think it's very important. People in this country are the ones who demanded, struggled, and asked for the right to information law to be brought in. They are the ones, people in the country are the ones who made sure that we have a right to information law. We will only have to, citizens will only have to protect it and strengthen it. So all of us need to collectively use the law, make sure that we constantly keep engaging, participating, filing right to information requests, and holding our governments accountable. Also, I think that the step that has been taken, about which we just heard, this certificate course, I think it's a very welcome step, and I congratulate the university and the Information Commission for organizing today's discussions, and I hope they're very fruitful. And I also congratulate you and wish all the best for this certificate course that is being done, because it is very important that information about the right to information law, how it can be used, the various nuances, is understood by students, by law students, by people, so that they can use it and they can strengthen the law. Thank you very much for having me here, and I look forward to being there in person sometime soon. Thank you.
Thank you so much, ma'am, for your valuable insights. And we also hope that we get to host you very soon in an offline mode on our campus. Thank you so much.
Morning to everyone. Madam has already given all the information, but now I say something different. Now, when the Right to Information Act was not enacted, then lot of movement took place to have such type of law so the people can participate in the democratic process. So it was done in 2003, the name was changed in 2005, and after all it was implemented. But now looking to the data, how much people are applying or using the RTI is still a matter of fact. Not more than 20% people of this country are utilizing the RTI Act, even though they are victim also. So now it's a time to have a popularization movement, not the enactment movement, but the popular. People have to take part and popularize the RTI Act and create the basic thing. Generally, people are not happy. Those authorities are there. The RTI Act is harassing us and we have to give the information. But the Supreme Court already say in the government, less secrecy is required and more openness is required, because the openness is also prevent the corrupt practices. So the Supreme Court say the sunlight is the best disinfectant. So if we are working openly in the sense of transparently, then there is a no hope for the corruption. So in Ahmedabad, Gujarat, we have started the Gujarat Mahiti Adhikar Pahel around 2002, before the act come into operation and started. Then every Saturday we conduct a meeting. Till today the process is going on. So those who have a problem come to us, those who have a different type of experience come to us, and we make channelize the system, and we also provide training to the government officer as well as the other officers who have to deal with the RTI and create a good mindset. Say it is not burden, but it is a part of your duty. And when you are discharging duty, then you may be credited. Otherwise, the act itself says the person who is not giving the information and found guilty, then he may be taken to the task and the departmental inquiry and other thing may be taken and the person have to suffer. Recently, the one Supreme Court judge also said that if the act is not implemented and the person is not giving the information, then it should be taken to the task. But how many such cases we have, it's a problem. Same way in child labor, imprisonment provisions are there. How many person is imprisoned? Not at all. So if we are not punishing accordingly and the severe punishment, then people are not taking very seriously. So act is there. But how it is implemented, how the people are participate, because the democracy is a participatory process. If we are not participating, then how we can have a good governance? So how we can fix the responsibility of someone, accountability of the someone. So now it's time to strengthen the people's. Actually, RTI says people have a power because the officer is duty bound to give the information. Earlier, where I'm doing my research during 97, 98, then I go to the police commissioner office to seek the information. They are not giving any information. Say this is secret, this is secret. Because they are giving, say, this is our monopoly. But now less secrecy is there. Otherwise, they have to give the people have a power. People can demand. But how many people are demanding? I'm also benefited by the RTI Act. When I was working earlier in some private sector, cooperative sectors, and my dues were not given. Then I make an application. They are not responding. I went to appeal. And finally, the appeal authority called me as well as the person who is the officers and say, why you are not giving the information? Give the information. You have nothing to pay. Only you have to give the information. And finally, because they are not giving the information because they have some corrupt practice. They don't want to give my dues and they want to siphon what the other account. And finally, I got my dues after 7 years. The thing is where we are ready to fight against the corruption, we have to do it and we have to create awareness about implementation. Act is there. People are knowing, but we know only by the letter, but not with the spirit. If people use it, then and then the corruption have no avenue to be there. I have also different experience. Sometimes State Information Commission say so and so person is harassing the institution and his application should not be entertained. But there is no any provision not to entertain any application. It is not the power and purview of the Information Commission. When the person went to the High Court penalized 10,000 rupees. So you are wasted time. The person is seeking information. Either you denied it. How you punish? There is no any provision under this Information Act. Only you, the information is not given, then you compel. If it is not required, you say as per law, you are not entitled to have a such type of information. But how you can debar anyone not to apply? His application is not entertained. So it is also create a bad impression. As well as the institution is also interested in the such type of application. They are creating the data. So and so applicant have a so and so application in month or year, and he not be allowed to make an application. But it is not a solution. He may apply through another name. So it is not the solution. Solution is why the authority is not giving information. It's the crux and it is the gist of this act. And sometime in a government or any authority, staff is not there. So it is also government have to provide a staff or some other thing so it can be implemented. Otherwise, it's a paper tiger. Because when I seek the information, sometimes that 24 hours given information when related to someone's life, then it should be given in 24. Who will interpret? Authority say it is not related. Then the person have to go to the Information Commission. Then it took time. So it should be clear cut. Such type of information treated as a important or life related information, it should be provided. And another thing is, say they are giving 30 days day. Now in a digitalization. So why it requires 30 days? If it is available, you have to pass very immediately. When you receive the information application, immediately it should be passed through the email or you can through the hard copy, it may be supplied to the person who is seeking the information. So it's create a good impression about the office also. So ultimately, for those who are working in authorities or in an office, they are working for public benefits or helping the people. So they got the good reputation in the mind of the society. So it should be taken as a positive. So how we can create awareness about the governance or government people, those have to implement this act. So they should take as a positively, not as a burden. I visit so many office and authorities to educate them regarding the RTI starting from 2005 to 2010 initial period. So they are, "Oh, I don't want to be a PIO. I don't want to be PIO because they have to give the information. But where you have and you have to supply. You have not to create. You are not required to be create. You have to provide the information. Sometimes if there is a less staff or some bulky information, then you say you come after 5 days and there is also a provision. You can inform the applicant. So you have seek huge information and it is old information. It took time and we will supply in due course of time. It may be taken care. But the people are so scared and they are fearful. So if I give something, then I may be caused out. So this is not thing. So now it's a time to create awareness. And at the same time, people are also misusing this RTI Act also. Because the person coming in a particular category, they have not to pay the fees and the information provided free of charge. So I once suggested you may apply free of charge, but if the information, charge may be taken from all the categories. So it should not be a burden to the taxpayers. You are free from paying the application fees, but you have to pay the charges of the material which you require if it is in hard copy. Then it also benefited to the state. So RTI Act is there, but how it implemented holistically, it's a matter of fact. So I suggest that the people power, really people use the power, because we know in a jurisprudence, the power can change the position of others. So how we use this power for the benefit? We have a lot of success story. In Ahmedabad, we make a campaign in 2009 and create awareness. Particularly the disaster when the earthquake took place and the people are not getting the compensation and the builder are not caught by the police. Then we also make a RTI to the court also. Then initially it was responded that the court is not duty bound to give the information. Say you are not duty bound to give your judgment as per law, but you have to give what is the status of this application. This state is application is pending, then they compel and finally they give the verdict within short span of the time. So we have to convince them. At the same time where this blood donation was going on and the private blood bank is also collecting and we seek the information and they give the information. So such type of blood is used by or supplied by blood bank to government hospital and private hospital. So the private hospital, very less patients are there and they are the elite family, the rich person. In the government or the municipal hospital, the poor people are there. They found only 10 or 15% blood goes to the private, this government hospital and most of the blood go to the private hospital. Then it creates a lot of havoc in the mind of the people and people stop to going to blood donation. Then we convince the people. It is not the way. The needy one should get the blood and you have to make the supply process whose applications are there because they are not selling but they are charging some process charge. But then found that the government hospital there is also people in need of blood for the operation and other thing. Then finally people are convinced and it was regularized. So many success stories is also there, but it depends how we have a warriors because we have armament, but only armament cannot success the war. It requires the person who deal with very commitment then and then. I think, and it is true, and we have a experience. The France have a modern 200 years old act, so they make a progress because there is a transparency. If everything is opaque, then we can't make a progress. So it's required a time, and now we are making a lot of progress. But in real sense, how many people are benefited and the beneficiary get the benefits or not? It's a matter of fact. So we make more and more activists, create awareness, also awareness in all the sphere, all the stakeholders of this act. Then and then we can get success. Thank you.
Thank you very much. Honorable Vice Chancellor, Professor Pawar, Professor Raval, Dr. Mann, my distinguished colleagues, faculty members, those who are present here, other delegates who are online present, and very dear students. In fact, whenever I come to RGNUL, I always have a feeling of nostalgia. Today, I'm glad that the seed which was sown a few years back, that has grown and it has taken the shape of a plant. I have got one. It was some time back, about 5 or 6 years back, when we received a letter from Punjab State Information Commission that they have a provision to disseminate the information about the right to information, and what could be a better platform than the university to disseminate this information by holding seminar and workshop, and that is how we started with it. And good that caste law has taken it forward. We published certain books also, and now I'm further glad to know that a certificate course has been introduced. Compliments to you all. My two learned speakers earlier who spoke on the topic have delved on the topic in quite detail and almost covered all the details. I would like to start with the apology, a note of apology that I'm not coming here with a structured lecture, but I'll share with you some of my scanty thoughts on the topic. We are one of the largest democracies in the world, and we know that democracy survives, or one of the pillars of a democracy is the rule of law. The rule of law has expanded so much that today we do not talk about those three conceptual formulations of Dicey which were given in 1885. But those formulations are relevant in a democratic form of a government. And to have a successful democracy, yes, we need openness in performance of public function. We need transparency, and we need accountability of the public authorities. And above all, we need all justice. And to have justice, we must have access to justice. I'm glad that Madam has covered in her address and subsequently referred to by Professor Rawal also, that it was not in 2005 that we got this right to information. The right to information, as Professor Anand Pawar also explained in his introductory remarks, was available to us under the Constitution. Normally, for the students of law, we talk about a legal right or a statutory right or a constitutional right. And we place the constitutional right on the highest pedestal. And as it has already been referred to, under Article 19(1)(a), we have a freedom of speech and expression. Now, if I want to speak something about, say, the functioning of Rajiv Gandhi University, if I want to write about the functioning of a university, I must have some information. And if I have a fundamental freedom of speech and expression, because expression can be by way of speech, or it can be by way of writing or gesture or words, whatever it may be. So I have a right to have information, and that right was recognized long back. Then similarly, this article, the Supreme Court have delivered many judgments that Article 19 is to be read with Article 14 and 21. I go a step further, speaking constitutionally, that Constitution also confers to all of us access to justice. Now, can we have access to justice in any form unless we have the relevant information, and particularly when it happens to be from the public authority? The question is no. The answer is no. So therefore, right to justice includes access to justice. Access to justice includes a right to information. So it was very firmly rooted in the Constitution as our right to information as a fundamental right. But it was little tedious that if I had to enforce my fundamental right, the remedy was that I had to go to the courts, maybe high courts or maybe Supreme Court of India, which every person cannot go, the ordinary citizen cannot go. And of course, there was a movement of right to information in the form of a statutory right in other country. And that is how from 2002, the first act came and which was replaced by 2005 act. And this act became the statutory right. But unfortunately, the hope which was there with the enactment of this right, that has been belied because of multiple reasons. One is you may or may not agree with me. I'll narrate you an anecdote. I had gone for a marriage in Haryana, a marriage of one of my students who invited me with all love and affection. When I reached in the village to attend a marriage, the boy who was the bridegroom, he was very much concerned that my teacher has come. So his all focus was on me. So ultimately he requested one of the elderly person to attend to me because he had to sit for the ceremonies. And the elder man came and said, "Sir, aap kahan se aaye ho?" That in typical Haryanvi language. I told that time I happened to be the vice chancellor of this university, RGNL. So I told him, so he was not very educated. So he said, "You make judges." I said, "No, I don't make judges, but I teach students who subsequently become judges." So then he took out a visiting card from his pocket and he gave me the name was written. And below the name, it was written here, Sarpanchpati. So I had heard about that. Who is Sarpanch, but what is Sarpanchpati? I said, I didn't understand. I said, "Meri patni Sarpanch hai, main uska pati." Similarly, why I quoted this instance, which you agree or may not agree, this statute of 2005 has given this right to all citizens. And suddenly some of us who are not having any other work, we have published our visiting card and they write so and so RTI activists. I fail to understand the 50% or more than that application which are filed. They are the so-called activists. They threaten the public authority. They threaten the public official. And as a vice chancellor, which I am presently also, I have been receiving or interacting with the official. They come, they will ask some favor. And when we say, sorry, it cannot be done officially, then I will file a RTI. I remember that when I was here and this campus was being developed, we purchased this telephone sets from a company called Siemens. And there was another company of Delhi which was rejected. Of course, competition was there. My colleague, they know, Professor Pasricha was also there at that time. Professor Pawar was also there. The company came, they filed RTI, and matter went right up to CIC, and we argued online the case, we won, and stricture were passed against that company. Now, the man came with the advocate, his father-in-law was running that company, and they said, if you don't purchase our sets, we'll file RTI. I said, why do you file RTI? Why do you waste 10 rupees? You tell me whatever information, I'll direct my official. If the information is there, we will provide. And if it, as Rahulji said, if information is not there, we will not create the information. So there are two things. There is nothing like, to my understanding, like RTI activist. I also have the equal right, as you have the equal right to information from the public authority. The right is equal. There is nothing like activist in this ground. Secondly, the public authority, the fear in the mind of the public authority should always go out. Because no public authority should have a fear, oh, RTI आगे अब क्या करेंगे, अब information देनी है कि नहीं देनी है, कौन सी वाली देनी है. Whatever is the information held by the public authority, you are bound to give that. And if any information is not held by the public authority, you're not bound to create that and you're not bound to give. So where is the fear? But unfortunately, what is happening in most of the organization where PIOs are appointed, PIOs have never gone through the act also. It's such a small legislation, nor they are educated about the act or about the duties and the responsibilities. Jurisprudentially, I'll talk a little bit on this right to information. Under Section 3 of the Act, every citizen have a right to information. But under Section 4, there is a duty on the public authority. Rights and duties, as we study in the jurisprudence, they go in hand. Now, if I as a citizen have a right, then as a citizen, I am also a part of the public authority. I also must perform my duty. Section 4, if I talk about the first part, the clause 1, this is subject to my economic capability or capacity. I have to digitalize my information. Professor Raval said, why to have a 30 days also digitalized? The question is, on one hand, we straight away jump to digitalization. Let us not forget that we are living, India is living only in the towns and the cities. The public authorities are in the villages also, where there is no internet at all. There is no facility. The signal is not there. What to talk about digitalization? During the times of COVID, when we switched over to the online education, 67% of the school children, they did not have the access to internet. What kind of education we provided? This is the all official figure. So if you go to the second part of Section 4, we have 17 duties given there. That what are the duties of 17 duties of the public authority? And if all public authority give full information about those 17, probably the number of applications will come. Not only that, all public authority, there is a notification by the Government of India in 2011 and subsequently in 2013 that each public authority is supposed to give a final report which has to be sent to the Chief Information Commissioner, and ultimately it has to be laid before the Parliament. Now, I don't know, I don't have the official figure, but my reading and understanding is that most of the public authority do not file such reports. So when you talk about the right, I have a right. I think 60–70% of are also part of the public authorities. Why don't we perform our duties? Rights and duties, they go hand in hand, and therefore that duty, if it is performed, it will happen. Then the definition of public authority. I have had the opportunity to receive a large number of RTIs as a Vice Chancellor of a public university. But when I went to the private university, I again started receiving RTI application. I said, oh, we are private university, we are not bound by it, straight away, without reading the act. But then I read the definition of public authority as it is given in the RTI Act. Any body or authority which is created having a self-governance. What is the meaning of self-governance? Then I asked whether the private university, though it is created by the act of the state, but it is falling within the definition of self-governance. And unfortunately, for a common man, I'm not talking about the law graduates, legal people. Legal people, we study the judgment of the Supreme Court, we say this is the law. But unfortunately, even Supreme Court and the High Court, they had to battle in the High Court and the Supreme Court whether judiciary is a public authority or not, whether the CJI comes under the definition of public authority or not. So similarly, the State Information Commissioners or the Central Information Commissioner, they have been giving contradictory rulings, and there is no unanimity on this issue. So you find on every issue, but I did not find many or any judgments on the issue of this self-governance. Then the reference was made to Section 8, which gives a certain exception where the information can be denied. Now, in Section 8, the public interest is in the mention. Again, what is the public interest? It is again the discretion of the PIO. or the State Information Commission or the Central Information Commission, before whom we file application and appeal, to decide whether it is a public interest or not. And this issue particularly comes more on the focus when we talk about the third party information. The procedure is very simple. If the PIO receives the application for information with regard to third party, it will have to be referred to the third party. Third parties whether say give information or don't give. It is for the PIO to decide whether it is in the public interest to disclose third party information or not. And those PIOs are not trained well. Most of the time they go with the third party decision. No, it should not be given. It says, since third party says, don't give this information, that may not be right. It may be in a public interest to disclose that information, but it is not given. So that Madam referred to the Data Protection Act of 2023, which was passed in August. Yes, but then law, by virtue of its dynamic nature, the law is evolving, law is developing, and the right to privacy has taken different dimensions. Right to privacy from 2014 to 18 in particular has expanded its wings probably beyond imagination, which we are not able to gear up to accept that. I give you another example. When in 2018, Navtej Singh Johor's case came, the same present sitting Chief Justice of India when gave the judgment, leading judgment, decriminalizing Section 377. Now, actually, the Supreme Court was in a fix. If in the recent judgment, which they have given 3 days back about marriage, right to marriage of LGBT AIQ, now, if they go by the liberal attitude which is taken by Navtej Singh Johor, they had to recognize right to marriage of the same sexes, LGBT. But thankfully, the bench is divided 3:2. Otherwise, our all laws, personal laws to the marriage, inheritance, or adoption, they had to be changed if they had it been a majority ruling otherwise. But on the other hand, jurisprudentially, if you analyze, which particularly my request to the student is, because the teacher know this part, but the student, you must understand, we do not apply mathematics to law. Law may be applied to mathematics, but mathematics is not applied to law. What do I mean to say? 2 judgments, Justice Chandrachud and Justice Sanjay Kishan Kaul, they are on one side. 2 judges on the other side, Justice Bhatt and Justice Narasimha. So 2 is equal to 2 cancelled. And Hima Kohli, who is the 3rd judge, has not written any judgment. She has just concurred with the 2 of the judges. So that becomes the majority. So ultimately, what is the ratio? Ratio is by one person who did not write the independent judgment. I mean, this is in a larger context that how the law evolved. But please understand, this kind of example which I have given is not applicable in law. We never cancel 2 by 2. This is just a hypothetical presumption I'm taking. So that is what happened. The judgments which we get from the Chief Information Commissioner and other. And another very important point, which of course has been discussed, who are appointed State Information Commission? Who are being appointed as the Central Information Commission? And are they appointed? Madam has pointed out certain states, they have become defunct. Why to talk about the state? In center, it is headless, no Central Chief Information Commission. And we know when the Chief Information Commissioner is going to retire. 80 applications have been received in February 2023 for the post of Chief Information Commissioner. From February 2023 to October ending, we are in the 3rd week of October now. The incumbent has retired, but we did not find a time to appoint and scrutinize. So when the central government itself is so reluctant to appoint the head of the institution in the country, the state are going to follow the same. Elections are never delayed. If they are delayed, we certainly go to the court. Cabinet is formed overnight. I remember sometime in one of the state, the president rule was lifted at 6 a.m. and the chief minister was appointed at 8 a.m. That is the hurry to the politician. So that political will to make this right to information a living reality to the citizen as a tool of access to justice is lacking in my point of view. That political will has to be there through which we can strengthen that right to information should be a living reality. Recently, on 9th of October, in fact, if you take from August 2023, 3 significant rulings have been delivered by the Supreme Court. All the 3 have been authored by Justice P.S. Narasimhan, and they are very good judgments. The earlier 2 judgments which were delivered in August, the directions have been given to comply and to comply with those directions by 31st of December. That is with regard to particularly Section 4 and following the directions which are through the notification of the Government of India in 2013. Those directions are for implementation of the Act. And the 9th October is the last judgment delivered by Narasimhan on this issue. K.C. Jain is the petitioner, K.C. Jain was of India. The particularly with regard to the functioning of State Information Commission and the Central Information Commission, that is given there and the direction have been issued. I sometimes fail to understand myself a statute which has been passed to educate or provide access to justice to the people. To enforce that, again, we have to file a litigation. So have we moved forward where we were before 2005? Or are we moving backward in the backward direction? That after 18 years, what are the function of CIC? And if the government is not performing, when we are talking about the objective of RTI, objective is transparency and accountability. Where is the accountability of those public officials in the government for not appointing the CIC or State Information Commission? Why the government are not being held accountable there? Then the very objective which is mentioned for creation or for passing of the RTI, I think that fails. In one of the K.C. Jain's petition, it is also mentioned that some of the State Information Commissioner are asking for the physical appearance. Now, if we are talking about the digital age, in particular 21st century or in 2023, then why should I be forced to come physically? If I can appear, I should have an option. Now, even the high courts and the Supreme Court are giving an option whether I want to appear physically or online. In some courts, it has already started. Delhi High Court has already established a ban. The Supreme Court is also moving in that direction. So that option should be given. But the most important thing for the success of RTI is, I think, twofold. No one should usurp the right of other. I should not become an RTI activist. Yes, I can file RTI on your behalf. It is a genuine. But many a times what happens, you ask for information on hosts of things which may not be required. What is the accountability on that issue? That may be there. I remember when this act came in Punjab from Nangal, the case came to the State Information Commission. The information asked was available with the authority, but it was in about 10 boxes, of big tin boxes. So they said, if you have to take this information, you deposit the money. So they deposited the money because you have to deposit only 1 rupee or 2 rupee per page, depending upon the rules of the state. Now, to photocopy that, how much resources of the state are required? You need whether that facility there or not, whether the photo, in some of the institutions, they are public authority, there is no photocopy machine available, or if it is there, it is of a bygone era which takes few minutes to photocopy, unlike the fast machine which are there. So we should not talk about only the rights. We should also talk about the duties, and we should also talk about the resources. We talk about the digitalization, whether digitalization is possible or not. Wherever it is possible, it should be done at the earliest. And in particular, the officials who are responsible for non-appointment of the persons as an information commissioner, they should be held accountable. I was invited to deliver a lecture to create awareness to the state information commissioner. This direction was given by the High Court. I don't want to name the High Court, otherwise you may figure out who is the person. It was given by the High Court that special training and awareness program should be held for newly appointed state information commissioner. I'm not talking about PIO, state information commissioner who hear the second appeal there. And to my surprise, when I was delivering a lecture, after 5-7 minutes, I just happened to say that please feel free to ask any question if you don't understand what I'm speaking, because I'm talking about laws. So one of the persons raised a hand and said, "Sir, you are speaking in English. I do not understand English at all. Can you speak in the regional language?" Unfortunately, I did not know the regional language. So if such kind of persons are appointed as the Information Commission on political grounds, then what is going to be the outcome of the right? So the balance of convenience has to be seen from all the angles, but I'm confident the kind of work which RGNL is doing and carrying on the work of creating a certificate course and this thing, that is taken seriously by the government, and we have the information commissioners on time, appointments is done on time, and the right becomes a living reality. With these words, I think I should put a full stop here. Thank you very much for giving me this opportunity and inviting me here. God bless you all. Oh, yeah, please. यही तो लिखे थे सुनते सुनते
प्रांगण में उपस्थित एवं सिस्को द्वारा सम्मिलित सभी गणमान्य अतिथियों, विश्वविद्यालय संकाय सदस्यों, विद्यार्थियों एवं प्रतिभागियों का हार्दिक अभिनंदन। सम्मेलन के इस गंतव्य चरण में मैं आज की आयोजन समिति की ओर से धन्यवाद प्रस्ताव प्रस्तुत करता हूं। राजीव गांधी राष्ट्रीय विधि विश्वविद्यालय की ओर से मैं आज के हमारे मुख्य अतिथि प्रोफेसर डॉक्टर श्री परमजीत सिंह जायसवाल जी का आभार व्यक्त करता हूं कि उन्होंने अपनी व्यस्त सारणी में से समय निकालकर आज के इस अवसर की शोभा को बढ़ाया। आज हमें आपके माध्यम से सूचना के अधिकार के बारे में एक अद्वितीय परिप्रेक्ष्य जानने का अवसर मिला। सूचना के अधिकार को जनमानस तक पहुंचाने हेतु हमारे न केवल आज के सम्मेलन परंतु लंबे अरसे तक चली आई सामंजस्य के लिए मैं हमारे सहयोजक पंजाब राज्य सूचना आयोग का आभार व्यक्त करता हूं। मैं हमारे आज के अन्य अतिथि प्रोफेसर मान एवं प्रोफेसर रावल का धन्यवाद व्यक्त करता हूँ। इसके पश्चात मैं हमें इस अवसर को सफल बनाने हेतु एवं इस अवसर के लिए मार्गदर्शन प्रदान करने हेतु हमारे विद्यालय के उप कुलपति प्रोफेसर डॉक्टर आनंद पवार जी का धन्यवाद व्यक्त करता हूं। अपनी इस भागीदारी एवं उत्साह से इस सम्मेलन को सफल बनाने के लिए आज हमारे साथ जुड़े हर प्रतिभागी का आभार व्यक्त करता हूं कि उन्होंने अपने उत्साह से इस सम्मेलन को सफल बनाया। अंत में मैं आज के इस अवसर के आयोजक डॉक्टर गीतिका, डॉक्टर रचना और डॉक्टर श्रुति गोयल जी का आभार व्यक्त करता हूं कि उन्होंने हमें मार्गदर्शन दिया और इस कार्यक्रम के आयोजन में सम्मिलित हर विद्यार्थी का आभार व्यक्त करता हूं जिन्होंने इस सम्मेलन की रूपरेखा को निर्धारित किया एवं अपनी दृढ़ता से इस सम्मेलन को सफल बनाया। Dear participants, you are informed that we'll begin with the paper presentation session within 10 minutes.
Hello participants, please note your sessions time from the sessions list that has been given in the mail and join accordingly. For the paper presentations, we'll be starting shortly.
Participants, we will be starting in 5 minutes. Please wait till you are assigned your breakout sessions and then join your breakout sessions accordingly.